want to continue on by talking about conduct that looks like an offer but might not be an offer. So we've already started that when we talked about Gibson ultimately. So we're part of working out what an offer is involves working out what it is not. So what kind of things are we looking at here? What kind of things are we looking at? Oh, that's right. I pulled the little thingamajig out. Let's fix that. Sorry about that. Okay, what are we looking at here? Why do we need to distinguish between kinds of conduct that look like offers and actual offers? Essentially because we don't have a contract if we don't have an agreement. And the easiest way to identify an agreement is to match an offer with acceptance that's been communicated. So the kinds of conduct that might not be offers, which come up in cases... Now, let me just take 2 seconds to stand back from this. Hundreds of contracts happen every day. You personally are involved in many contracts most days. Very few contracts, if we think about the scheme or the total number of contracts, end up in court. Most of the time when people end up in court, it's because they can't actually resolve their dispute any other way. So again, my mantra, I have it on a card. It says if you're trying to learn how to write contracts by looking at cases, it's like trying to work out how to have a happy marriage by only speaking to divorced people. You'll get some relevant information for sure. It's largely about what not to do, but it's not giving you that positive information about what you do need to do. And so a lot of what we're doing here is when we're looking at cases that distinguish conduct from that we might think is an offer otherwise, there is at least one party, the party who somebody's pointing at and saying, you made me an offer that I accepted, doesn't want to be in that contract. Okay? So they're arguing like Carl and Carbolic Smoke, like Carbolic Smoke Ball did in Carl Hill, that they never meant for it to be binding. They had their fingers crossed behind their back when they said it, or you should have known that it was a puff. Or like in Gibson, I was just trying to get information to find out if you'd be interested in entering into a contract with me. I was giving you the framework under which I might be prepared to contract, but I just need to find out if you were interested first. Sometimes it might be a supply of information. And then we're also going to talk about a specific type of contractual arrangement or negotiation, which is an auction or a tender, and where that works. So let's have a look. So the key thing, and this is the bit that you'll go around and you'll afterwards, and for many of you, it'll just do your head in for a week or so, and then suddenly some light will flick and you'll be thinking like a lawyer and you just won't get it, that other people don't get this. All right, so you will get it, even though it may not make sense to you initially. So this is this idea of an invitation to treat. I think it's time for some role playing actually. I just feel like we need a little bit of more movement in the room, and I need some people whose names I don't know. I don't know your name. I know you're trying to hide from me, but you look lovely and we'd really like to know you. Let's all point this way. So you don't have to be in the front of the class, okay? You can do it at the back. Come on, come with me. What's your name?
Tatiana.
Tatiana. We have met before. Yes. What's your name? We haven't met either. Leia. Leia. Nice to meet you. You look lovely too. Come on. Tatiana and Leia. Okay. I would like you to sell this pointer. You guys at home can't see it. To Tatiana. I think in your shop, where's your shop? It's a lovely shop here. Okay, there's the shelf. You can have it on the shelf. Can you just put it on the shelf? All right. Now, Tatiana, you're going to go into the shop. You're going to have a browse around. You're going to find that beautiful pointer or something else on these shelves. And you're going to, it costs $10, by the way. And you're going to go grab it, pick at it, and then you're going to go to Leia and purchase it. Okay, so what's going to happen here at the, what? Have you got a cash register or something? have a little chat.
That'll be $10.
Okay. All right. So did you see that? Purchase $10. I usually have money. I forgot to bring the actual my Monopoly money. So you take the wine. Okay. Good to know. No. Because I know when the contract's binding. Okay. So basically, what's happened here? So Tatiana's come through. She's found something in the shop she likes. She's gone up here. And so what has she done? Has she made an offer to purchase that thing? Okay, we've got some people saying yes. Some people saying, why are you asking that? Of course she's made an offer. Leia here, did you accept the offer?
Yes.
Yeah, she's not so sure. Well, she hasn't seen the $10, all right? So let's assume that $10 has changed hands. You might give her that. We've walked out. We've got a binding contract. There was an offer made. The offer was accepted. Are we right? This is where I walk down here very quickly because I should have thought this through better when I made this up on the spot. And I say,
No.
no.
No. No.
It's only saying it one way.
No.
Okay. No, you're all wrong. You're all wrong. Go away. Let's go through it again. I will guide you through this. This is a shop. She made you the offer.
Yeah, I just agreed to buy it for $10.
So you agree. See? Yes, I need the yes now. Congratulations. That's basically what happened. So we have here in our shop or on our menu in our cafe, or wherever we are, Tatiana, we'll go purchasing together, all right? So we like this. Oh, I think I might like to buy this. Oh, no, I've changed my mind. I'll put it back. Instead, I will buy this. I'd like this, please.
That'll be $10.
$10. She's offered to sell it to me for $10. I accept that offer by giving her $10. We make that contract. So when I go into the shop, I buy from her. So, and as I've said that, I've actually explained it wrong. It's sitting there on the shelf. What's actually happening is I'm offering to buy it from her. She's accepting my offer at that point. I just realised I'm getting all caught up in the drama of this running around the room. I just feel like, okay, I just need to go.
No. N-O.
Exactly. So I was confusing you more. I do this every time. I don't know why. We all get ourselves all confused. So what we really need to understand is that in any retail situation, buying a cup of coffee, thank you, these guys have just done it. They can reenact it as well. Buying a cup of coffee, buying something in a shop, you can sit down. I just want to learn your names. That's why I'm just hassling you really more than anything else. Doing any of this, when a customer comes in, a customer finds the thing on the shelf, usually has a price tag on it, or goes up to the counter and says, I'd like a coffee, please. Again, menu will say what the price is. You might not actually go through all of those details. It is the customer who makes the offer, and it is the store that accepts that offer. Okay? Because the store itself is inviting you to treat. Very old-fashioned language. Treat, in addition to meaning things like chocolates and candy, treat means negotiate in this sense. It's an invitation to negotiate, an invitation to bargain, an invitation to enter into a contract. So when you are going to a shop or you're looking at an advertisement and you're thinking, they're offering that for $10, actually they're inviting you to make an offer of $10 to them. So one of the things that happens that often gets raised with here is, how many of you have been in a supermarket and the price on the shelf is different from what happens at the cash register?
Oh, I love that.
Yeah.
Love it. Why do you love it, Michael?
Especially if it's like when you're dealing with a lot more expensive item and, say this is it's worth $2,000 and it says $900 because yeah, they have to give it to you for 900 bucks.
So, and they do. The consumer law now says, yes, that is what they have to do. If they are marking or advertising goods for a price that is different from what it rings up out of the cash register, essentially the legislation says lowest number wins, right? It's up to the shop to put the price at which they're prepared to accept an offer and keep that accurate. And so you get the lowest of those two prices. I'm completely oversimplifying, but that's what it is. Let's not worry about the legislation too much. We will get to this legislation at some points. I want you to understand the common law principles first. So, the question, again, for the reasons that we've already talked about, of working out when a contract is made and exactly what the terms are and whether somebody is bound or not, the question keeps coming up, who made the offer? Because the party who has the power is the one who can accept. Remember, an acceptance, and we will go through in a lot more detail when we get there, but an acceptance can't vary the terms of the contract. Once an offer has been made, a contract can be formed just by saying yes. So let's have a look. Fisher and Bell. So this case, it's not actually in your textbook, but I think there is a copy of the case anyway. So the context here is that it was illegal to sell flick knives. So it's illegal to offer them for sale. So I'm assuming it was, I always get them parties, I can't remember how many appeals there were. So I'm pretty sure it was Mr. Fisher was running his shop. Might be the other way around though, it doesn't really matter. He had some flick knives in a display cabinet. Mr. Bell, being a policeman, came into the shop, said effectively, are those flick knives for sale? Mr. Fisher says, yes, they are. Keep reminding you I might have got the surnames around the wrong way. Mr. Plod basically says, hello, 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 what have we got here then? I'm going to take you down to the Nick because it's an offence to offer these things for sale. And Mr. Fisher, quite possibly being connected to the mob in some way, says, hang on a minute, there's an invitation to treat. You offered to buy, I didn't offer to sell, so I have not contravened the Relevant Crimes Act. Clever, hey? And the court agreed with him. Now, anybody doing crim at the moment? Have you talked, a few of you, have you talked at all about the burden of proof? So in a criminal law situation, we are looking at a beyond reasonable doubt standard as well. So there needed to be no doubt as to whether or not he was offering them for sale. So that burden of proof may well have impacted this. So here, in relation to this case, so the idea of offer for sale needed to be understood in the context of the Act. So that term must be given the meaning attributed to it in the ordinary law of contract. And as they're under the display of goods in a shop window with a price ticket attached is merely an invitation to treat and not an offer for sale. So just putting them in the window wasn't enough. So what do we think about that? I can see you think it's funny. It's gone. Emily.
Yeah, I've just got a question on that. Would that be different if he had a for sale sign in the display box?
Might have been, if it was, particularly if you had the words offer for sale, yes.
You are openly expressing that it is for sale.
Yeah, look, it might have been. I mean, we're looking at it in the context of this one piece of legislation here. I think the point I really wanted to make is I don't think this is a bad result, actually, because I think that if you're going to write legislation that stops people from doing stuff, you've got an obligation to get the words right, okay? So actually, and it's no secret at this stage that the invitation to treat existed. So yes, he might have done things differently, and we'll look at a couple of other cases that are similar. So in fact, the next one is Partridge and Crittenden, which just kind of amuses me because it involves birds and he's got a bird's name. But so Mr. Partridge paid for an advertisement in that I'm sure you all subscribe to it, actually, the classified section of Cage and Aviary Birds. And, you know, and basically he advertised that Bramblefinch cocks and hens, 25 shillings each. So it turns out that under the local law, it's a criminal offence to trade or sell birds. And so he was fined for the offer to sell. Once again, the same issue. Was he offering to sell the birds? Or was this just a supply of information? Was it an invitation to treat? And it was held ultimately that it was an invitation to treat. So he appealed the decision that he was found to be offering local birds in that way, and it was held that there was no offer to sell, so he didn't contravene the legislation. So again, we need to be really precise around the language. Joseph? These are old English cases and they involve the police as well. So often the informant's name will be in those cases. So you might have, sometimes, because these are English cases as well, so sometimes you'll have R for Rex or Regina, so which is the same as the state or the whatever. You might have the name of the informant. So in the one before, Crittenden and Bell, so now I've mixed them up, Fisher and Bell, sorry. One of those was the police officer, was the informant. I don't remember why in relation to this one. The law is not a science. Unfortunately, it doesn't always behave consistently. The one thing that will be consistent is that at first instance, you will always have the informant or the person bringing the action, the plaintiff, and then from that point onwards, the first party will always be the appellant. So, but then sometimes you just got to keep the stream in your brain to work out who they are. So, we've had a few people who are in Manchester, so people who spent some time in the UK. Anybody been into Boots? I love Boots. I don't know what it is about Boots that I love, but it's like kind of like Priceline Chemists, but like on speed. Literally, you can buy it there. And like everything else, it's their massive, massive stores, and you can buy everything from, you know, discount nail polish through to vacuum cleaners and heating systems, and like they just seem to sell everything. So this case goes back to 1953. So the actual facts happened, I think, in the late 40s even. So Boots actually, and this is like photo from the 50s of Boots. So Boots kind of disrupted the local chemist shops. They were the first sort of big footprint chemist, pharmacy, sort of almost like a mini department store in the UK. So up until Boots started selling everything that they sell there, if you needed to go and get your prescription, you went to your local pharmacist. And so the Pharmaceutical Society of Great Britain is and was, for pharmacists in Great Britain, the equivalent of the LIV, the Law Institute of Victoria, for lawyers here in Australia, or lawyers here in Victoria. It's a club, it's a cartel. It's basically, it's our union, their union. It's, you know, it's an industry body. It's keeping, really looking at the rules and regulating the profession and looking at how the profession works in a particular context. So basically, the Pharmaceutical Society brought an action against Boots Cash Chemists because it said that the way that Boots ran its stores was in breach of this legislation, the Pharmacy and Poisons Act. So the Pharmacy and Poisons Act said certain types of medication could only be purchased under the supervision of a pharmacist. So the words were, the sale must be effected by or under the supervision of a registered pharmacist. And the way that it actually worked is, so, and in fact, I was thinking about this case the other day because I think from the beginning of this month you can't buy codeine in chemists anymore. So, and I think I've always used codeine as my example, that, you know, you need to have a prescription. But there are certain kinds of medication that you can only buy at a pharmacist, but they're not actually on the shelf. Where all of the medications that were concerned here, they had the medications on the shelf. You could go and you could pick up your little basket, put it over your arm, you could put in your medication, you could add in a discount nail polish and some orthotics and all of those other wonderful things you can buy there, and then you front up like we did to Leia at the, did I just get your name right? Leia. Layla. Leia. I'll get there. Blah, blah, blah. I'm speaking before I'm listening. And you make the purchase there. So the issue here was whether when the customer picked up the drugs that were the subject of this legislation, whether they were breaching, Boots was breaching this act by letting them do that. Because the process of picking up the drugs and putting them into the basket or just carrying them to the cash register was not done under the supervision of the registered pharmacist. So the plaintiff, or the pharmaceutical board, argued that the drugs were purchased and the contract was made when the customer put those drugs in the basket. And as that transaction wasn't supervised by the pharmacist, Boots were doing the wrong thing, and so they should go to jail, they should not collect $200, and they should stop disrupting our wonderful profession. The defendant, or Boots, said, well, the legislation hadn't been contravened because when the customer took the drugs to the cash register, that was when the customer made an offer to purchase the drugs. And once you have an offer, there is no contract. The contract can only be made when that offer is accepted. And so the supervising pharmacist at that point could say no. Just the same way as when, you know, your teenage kids go and buy or attempt to buy alcohol or cigarettes. They go into Woolies or whatever, I can't remember what they're called. They're Dan Murphy's, sorry. Go to Dan Murphy's, they can walk around that store for as long as they like with a bottle of gin in their little basket. But when they get to the front and they try to pay for it, one would hope that the person at the cash register can say, no, I do not accept your offer of $75 for this bottle of vodka. I reject your offer. It is not accepted, no contract made. So they argued that the sale was effected by or under the supervision of a registered pharmacist because the sale only occurs, the contract is only made at the point when the pharmacist is there to do it. And I suspect it will not surprise you at all now that we've gone through that process that Lord Justice Somerville agreed with them. If the pharmaceuticals argument is right, once an article has been placed in the basket, the customer is bound and would have no right, without paying for the first article, to substitute another article which he saw later of a similar kind and which he preferred. And I think that's probably the best way to think about it, that you go into the shop, you gather the things that you put into your trolley or your basket or your hot little hands, but it's only when you go to the cash register that you make an offer. So what? I can see this, I bet we're thinking the same thing, Kin. What about those bloody automated shopping things? We're not thinking the same thing?
I'm trying to ask this. Occasionally I see people shopping in Woolies and Coles. They will have to put their mouth before they even reach the counter.
Ah.
So is there a fault? Is there a law?
Okay, let's analyse that. So Let's analyse this from a contract law point of view. Kin, I'm using you as an example. What kind of fruit do you like, Kin?
No. Durian.
Durian. Oh, man. No, you can't eat durian in a shopping centre because that's like offensive on more than one level, okay? Apple. Okay, so we're not going to like, I can't have a smelly fruit in this situation. So Ken has gone into the supermarket and he's putting things into his trolley, and while he's going, he's chomping on the apple that he brought there. When he gets to the checkout, he either forgets or decides not to mention that he ate that apple. From a contract law point of view, what's happening? So has he breached a contract? Or is there a contract that he might have breached? No. Okay, Emily's looking very certain. Let's see, she wants to be the QC. She doesn't want to be the junior. So, why not? What?
Because if all the goods displayed are an invitation to treat, and
Treating
he took a treat as opposed to...
if they're an invitation to treat and they're not actually going to, it's more of a criminal matter rather
Yeah,
than...
I think it is a criminal matter, absolutely. So what we've got, and to the extent that there might be a contract, there's an implied contract that you have gone into somebody else's space. We could get some tort in here as well if we wanted to. You've come into somebody's space, they've let you into their premises on the condition that you don't take their stuff when you leave, unless you offer to purchase it for the price that's displayed, and you walk out only with the items that you've purchased. Woolies actually have apples and bananas for small children at the door these days, by the way.
He still want to pay, but he just eat it halfway.
Yeah. Well, actually, at risk, one of my best friends in the whole world, the first day that I ever met her was like my second day at university, and I was completely overwhelmed in this law degree, and she was like a couple of years older than me, and somehow she'd ended up, we were together, and my mother turned up, and this woman is actually, she's very large. She's very, very large, but she's a very big girl. And my mother started telling this long and involved story, you can see where I get it from, about how she'd been behind this really fat guy. She must have said how fat he was like 700 times. So I'm just like completely dying of humiliation. And how they get to, he's got all this stuff in his trolley, and then at the end he pulls out a banana skin and says, "I ate a banana." And then they have this long conversation about whether they should get a banana of equivalent size and weigh it to work out, or whether they should give him the banana or whatever. And in the meantime, my mother's stuck behind this very large person and just humiliating me. And it's sort of become this code word in my friendship with this woman. It's just like, how was your day? Anybody eat a banana? So, I think this is actually, it's probably more, now I've lost my slides there. It's probably more an issue around what rights you have when you enter the premises. What I think, with respect, my learned friend, is a slightly more interesting question in this day and age is what happens when we buy stuff and there's no human at the other end, when we do self-checkout? Well, I don't really want to explore so much the issue about what happens when we lie to machines. Like, I'm thinking machines lie to us all the time. Let's explore that. If I'm still teaching tech law, we can talk about that then. But just from the point of view of a contract, do we need a human to make a contract? Why not? Or why? Like, I mean, we've got two parties. So, Ryan, am I getting that right, please? I need...
You make a contract with an automated system because someone had to program that system. So everything's in there.
So if I'm making a contract with a machine, am I making it with the person who programmed the machine?
Indirectly, yeah.
Am I? So if I'm at Woolworths and I go through an automated teller at the end, what do they call it? Self-checkout. Am I making a contract with Woolworths, or am I making a contract with the programmer of that machine? Woolworths. Yeah, so it's an agency issue. And actually, you know, and I'm asking this is a kind of a ridiculous question, but I want us to unpick all of the details.
Because it would be the same regardless of the fact it's a machine. Even if you go to a normal checkout chick, you're not making a contract with her or
Absolutely.
the company that they're representing.
Absolutely. So the member of staff that you deal with, or these days the machine, is essentially representing the corporate entity or possibly the individual. So your local cafe, when you buy a coffee, you might be buying directly from the owner. You might be buying from a staff member of the owner, if it's a sole practitioner. You might be that the person who calls themselves the owner is probably a director and the sole shareholder of the company that either owns the franchise or owns the business. So again, because we're lawyers, we're going to get stuck on that detail, okay? We're going to have to unpick who are we doing business with, because particularly in a bilateral contract situation, an offer can only be accepted by the person to whom it is made. So identifying to whom it is that you are making an offer, or from whom or to whom an offer is made, is a really important part of the process. And it will seem a little bit ridiculous, and it kind of will come without thinking later on, but it's often a trick for young players is not actually identifying who the right parties are. And we will talk about it more when we get to privity, but being able to unpick who are the contracts to the parties, who are the parties to the contract, I should say, helps us identify who has rights and who has obligations. Because it's no good having rights that you can't enforce. So, and parties to a contract will always have obligations because consideration is one of the elements, and we'll unpick that a bit more later. But they don't always have rights. Sometimes the rights go to somebody else. And so if the person who has the rights can't enforce them, that can be quite tricky. Michael.
So parking in the car park will fall in the same category?
So parking in the car park? Yeah, it's a good example where the owner of the car park is usually not there. We're going in and out using a machine. Absolutely. And, you know, I just use this as an example right now to just help you think about it slightly differently. How are we doing? I've got half an hour, but I'm going to try and finish in 15 minutes because I understand the train things, and that's what we're going to do. Another kind of conduct that we see regularly, which might look like an offer, smell like an offer, feel like an offer, but not be an offer, is a supply of information case. So ultimately the court found in Gibson that it was an invitation to treat, but I think there is a way of looking at Gibson that there was a supply of information as well. The fact that it went further than just a straight supply and asked Gibson essentially for the expression of interest suggests an invitation to treat. But we have cases where there have been discussions about whether there is a request for information. So this one's discussed in the textbook. I can't remember if it's actually in a case book or not off the top of my head. So Bumper Hall Pen was a piece of land in Jamaica. And so the telex came through saying, will you sell us Bumper Hall Pen? Telegraph lowest cash price, answer paid. The response suggests, provided the information as to the lowest price that they might consider, but didn't actually say, yes, we will sell you. Just provided the information. And it was found to be a supply of information, not the acceptance of an offer. Now, the telex is kind of the old-fashioned version of the tweet, right? You used to have to pay by the letter. So telexes and telegrams, often very short, very concise, not a lot of detail. So you end up with misunderstandings, and we have issues around certainty as well. So what are the key takeaways for these kinds of behaviours? And we'll come back and we'll do auctions and tenders next week. The things I want you to think about. An offer in order for, or conduct, as in what we say or what we do, in order for it to be classified as an offer at common law for contract law, it needs to be capable of ripening, to use the word from Carhill, into an agreement by acceptance. So it needs to convey a willingness to be bound and the price or the consideration which the offeror seeks in response. In order to work out whether an offer has been made or not, it doesn't matter whether it's made to the whole world or to a specific person. That doesn't affect its validity as an offer, but it might affect who can accept it. So if I make an offer to Taps, Kin can't accept that offer. But if I make an offer to everybody in the class, either can accept that offer. We haven't really talked about this so much, but this idea is that an offer needs to be communicated. And there are a couple of other cases that we'll talk about next time. You need to be aware of an offer in order to accept it. Again, most of the cases that deal with that, I should have been a judge. I'm a very judgy person. I think a number of those cases have been decided the way they are to get out of paying rewards to people who the police might otherwise have had an interest in, because a lot of those cases are about there's somewhere, somehow you can get a reward for assisting the police with their inquiries, and people who assist the police with their inquiries become ineligible for the award, sometimes on the basis that they didn't know about it in advance, which seems a bit ridiculous, but anyway. But that's how the law has evolved. You need to know about an offer in order to accept it. The offer itself ultimately needs to include all the material terms, all the important terms. So the terms need to be communicated before acceptance. You can't add in another term later on. An offer, none of the cases we've talked about yet deal with this, but we will keep going next week and we will keep dealing with it. It can actually stipulate how it's going to be accepted. So we'll talk about that particularly with the postal acceptance rule. So I can offer you something and say, you can accept by sending me a letter. You can accept by interpretive dance. You can accept over Twitter. If I stipulate how you need to accept, I can deny your acceptance if you haven't accepted in the way that I asked you to. And offers, okay, they can lapse. They can be terminated, they can be concluded, sometimes they lapse in accordance with time. Again, we will talk about that in more detail. So whether something amounts to an offer or a request for information or an invitation to treat will be a question of construction. Here I'm talking about construction of the evidence or the written word. So ultimately, the court construed the documents in Gibson in order to work out whether or not there was a contract. So it's important to look at what happened objectively from the point of view of the reasonable person. The subjective or actual intention or the actual understanding of the parties is not relevant. What is relevant is what a reasonable person would have thought given the information available. Let me just see where we're at. So I would like to start next week by talking about auctions and tenders.